Yes, that's the sun noise, my companies. Just making sure the alerts are on my watch. Yeah, we still got like 5 minutes. I'm not starting early. You are at a 10 a.m. panel on the last day of the convention with the cons lawyer. I am not starting anything early. Quite frankly, we're lucky I'm here, not crying down by the river at this point.
So,
It's not too late. Oh, it'll happen, just not until after closing.
The van down by the river. I don't know if anyone gets
Okay, you laugh about that, but Alkali has a van. And it's what he uses to travel to shows with back when we go camping, things like that. He brings that. Well, let's park it at the lot over where the trailers for the block party are. We're sitting there under an awning in front of his van yesterday. The van, they got somebody to make him a button that reads "The free candy is implied." And somebody walks over and goes, "Oh, are you sitting in a van down by the river?" We're quiet for a minute. And I look at it and I hate you. That's exactly what we're doing today. Oh.
So, do you know a good place you curl up in the fetal position and just start crying?
Yeah, just anywhere.
Okay. All right.
We've actually, if you become staff, you get access to our room, and that's all it is. We have pillows. It's wonderful.
so do you actually work for the convention as the lawyer, or are you just, I assume
Myself
you were
and
just,
Buddy Goodboy Esquire provide on-site legal support to the convention.
okay, I assume you were just some furry that happened to be a lawyer.
No, there's a lot of those.
No, he's a lawyer that just happened to become.
Yeah, that's it. That's the best way to put it. Oh.
I mean, like, you were like here to do shows and stuff,
Yeah.
but I didn't realize you would be
This is
at you work.
the shows. The shows are how you all keep me giving you like legal guidance at any point in time, because after about the 18th weird situation I get emailed or texted with, I'm like, yeah, you're gonna give me an hour on stage to be an idiot. That's how it works. No, that's not how it works. I'm not blackmailing the cons into getting stage time. Because I want to be really clear before one of you guys goes on social media. I'm not
I already did it, but I only had suspicions. I didn't have any evidence.
Boozy Badger admits to blackmailing.
blackmail cops. Blackmail there's some difference.
Are you seriously cheating?
No.
It'd be wonderful if there were, wouldn't it?
So is any non-monetary exchange blackmail?
No, this is, it's even Buddy and I, it's not a situation where we're paying for it. We provide the guidance on site to the convention. Can we do this? Yeah. Can we do that? Please no.
You did what?
That wasn't enough.
It's the funniest please don't that you've ever had them ask you.
Right? Oh my God.
That or
Oh,
be able
no,
to,
actually, I can tell you right now. About 2 years ago, after we came back from COVID, and the waterfront became a big thing at night, right? The next year, they're like, oh, we should make that an official event. And I jumped into that chat very quickly. I said, please don't, please. Well, but it's really popular. Oh, you mean the thing with a lot of furries listening to EDM music late at night, directly beside the river? This isn't a gentle slope, that's a wharf. There's about 30 feet of water underneath that wharf. Please do not make it a formal event of Anthrocon to have people in low visibility fursuits dancing at night inches from death.
Why not?
All we need is fursuiters popping up downriver. Especially when the con chair won't stop making jokes about throwing bodies in the Allegheny River.
it's like a reverse Japanese lantern festival, like some family 2 miles down south looks out to the river and sees a single head pop up, and then like 5 more, and then all of a sudden it's a whole sea floating down.
You all see the Jeffrey Giraffe fursuiter? Hilarious would it be if like some kids having a picnic right outside of Pittsburgh, looked in the river and Jeffrey Giraffe's floated body floats by.
Grave of the furry flies.
Oh dear.
Would any kids say no?
I mean, not doing. Alright, we got 1 minute. At some point I was supposed to get a battery and a charger for my phone. That does not appear to be happening.
What kind of phone do you have?
An electric one?
Android.
One that has a battery that needs
iPhone.
charging.
It doesn't matter because it's one of the new iPhones with the USB-C chargers.
Oh shit. Okay.
Oh, they have USB-C chargers
I have a
now.
10-foot cord.
I have a 10-foot cord. Wonderful. I only have 9 feet of space between me.
No, me first. No.
One supplies the cable, one supplies the charger.
Okay.
You fight each
Oh
other.
my God! I love you.
External battery network.
Congratulations! you
Make
just
sure
won my
I'm
favorite
not
panel.
guilty on the next one. Not guilty.
You all just became my favorite panel crowd. Good morning.
Good morning.
You can tighten up if you want, or stay seated out as far as you want. I don't care. Some of you haven't showered. I get it.
Yeah.
Funny you did that because in my state they just charge someone who's trying to
I'm
private.
going to give you the best life advice you're ever going to hear. Right after I say the words, some of you haven't showered, don't say, funny you did that. Because immediately I'm like, I heard that and I'm going, are you about to admit out loud you haven't showered this weekend? Because, oh my God. We had a panel specifically about that in here on Friday.
If you want me to take the oath,
I didn't shower
If you want
last
me to
night. I
take the
showered
oath.
this morning.
I'm also going
Define a shower.
So welcome to Basic Law.
Yellow doesn't
Let me
count.
explain how this works, okay? This is I call it the Boozy Lazy panel. Because we're going to discuss a basic legal principle, but we're going to do it in the Socratic manner. Who knows what the Socratic manner is? Yes. Yeah, you're a ringer. You've done this before. Yes.
Well, I'm also a philosophy professor.
Yes, I remember.
Socratic method.
By the way, best person to have on this panel because they give answers that are like, well, this would make sense. So, obviously, that's not what it is.
The Socratic method is when you learn through asking questions.
Correct. And the reason we do it like that is the Socratic method is the way that they actually teach you law in law schools. And that's a misnomer because they don't teach you law in law schools. There's no giant book O law. It's not how it works. But they teach you in law schools how to read a case, interpret a case, talk about a case, and apply a case to new facts. And that is thinking like a lawyer. That's what they actually teach you in law school. So essentially, on top of my BS bachelor's in and I'm not joking, antebellum, Southern Appalachian, German Palatinate migration,
Yep.
I also pay $125,000 for a fancy philosophy degree. It's like, we're teaching you to think like a lawyer. Oh, God. It's just a bunch of people in a classroom screaming the word money over and over again. The Socratic method actually originates as a way of teaching law at Harvard Law School. There's actually a famous book that we suggest to everybody who is considering going to law school. It's called 1L, and it is a biography or a memoir of the writer's first year as a law student at Harvard Law. And they were talking about how when you start at Harvard Law, they take you on a tour of campus, and they show you everything. And there's a library on Harvard's campus called the Widener Law Library. And they pointed that out, and the tour guide at that point said that library is named after Dean Widener of the Harvard Law School, the inventor of the Socratic method. May he rot in hell. You come in, you are assigned cases, you come in, you sit down, there's a professor at the front of the room. We are given assigned seats. Do you know why? It's not for order, it's so the professor doesn't have to remember your name when he tortures you. You are given an assigned seat. You sit down. The professor will walk in and say, Mr. Badger, what is the holding of Smith v. Jones? Hopefully you read Smith v. Jones the night before like you were supposed to, because they don't tell you they're going to do this. They just pick your name and start. And for the next hour, you are being tortured. You will be asked every single question. As you answer a question, right or not, the professor will turn around and answer it. All right, but let's change the facts to this. What then? And then you have to argue that. And if the professor thinks you're wrong or he really wants to challenge you, then he'll turn and he'll go, okay, what do you think of Mr. Badger's answer? And then you answer. You give a very coherent answer that sounds right, and they go, Mr. Badger, how do you respond? And they'll do that for the solid hour. It's a nightmare. Unless you're like me, because I found out that there's websites doing things called case briefs. And case briefs tell you the answers to all of those things. You still got to think on your feet, but you don't have to do the reading. Hence the reason I didn't give any of you reading today.
Spark notes?
Say what?
Like Spark notes for like wall cases?
Yeah, except they cost a lot of money to access unless you're me and you just make a deal with somebody to get their password.
Well, it's the professor who uploaded them. He's making bank off you.
Why did the professor upload it?
I'll tell you what, the professors already make a lot of money. Yeah.
But they could make more.
Yeah, anybody ever had a college course and the professor's like, this book is required reading, you must have it. And then you look at the cover of the book and it's the professor's name on the book and they don't cut you any slack. Yeah, law school professors are like that, only worse. Because their books, you learn the law through reading case books. And what it's a collection of jurisprudence, it's cases that have been decided in areas of law, and you read them to glean out the common concepts, and then you flesh everything out through discussion on it. These cases are hundreds of years old. You know, there's cases from the 1700s, there's cases from Britain, there's cases from 80 years ago. These cases have not changed. The basic principles have not changed. Yet somehow every year your contracts professor has edited a new edition. That said, typically we pick a normal, just kind of easy topic to go off of. We've done contracts. We've done promissory estoppel. Last year we did bankruptcy. So this year I'm going to do something that's near and dear to everybody's heart that you will probably, I always say, you'll never use this, but I am in a room full of furries at 10 in the morning. You will definitely use this. Let's talk about the 4th, 5th, and 6th Amendments to the United States Constitution. How's that sound?
Yeah.
Who knows what those are? Oh my God.
I invoke my fifth.
You're all going to jail.
I know that!
I'm elected.
Yes, in the back, please, dear God.
I'm not sure about the order of that, but self-incrimination, right to a fair and speedy trial, and that's it. Well, fifth is
There we go.
Yeah.
You got all three of it. Actually, there's more to those, but those are the things that people always think of. The 4th Amendment is your right to be free from unreasonable search and seizure in the United States of America without a warrant issued by a magistrate. Your 5th Amendment right is your right against self-incrimination. You cannot be compelled to participate in your own incrimination. Your 6th Amendment right is your right to a speedy trial, your right to counsel, and the right against double jeopardy. All right? What's double jeopardy? Do not, I swear to God, if one of you says it's a subject on a TV show. Yes.
Me?
Yes.
It's like when you get punished twice for the same crime.
Correct. That's exactly what it is. What do we mean by that? When we say punished twice for the same crime?
Being tried.
Well, actually, yes and no. And I say yes and no because there's one important distinction to what you just said. Yes.
You can't be put into a trial for the same crime twice in a row, or twice.
Okay. Yes and no, once again. Yes.
Basically, let's say you were found innocent the first time, and they decided to bring evidence against you again, try you again. You can't try however you already tried and found either innocent or guilty the first time.
Did you say the same evidence?
Not necessarily the same evidence, just in general. Let's say they come up with new evidence that you've already been tried.
That is the most correct. By the way, in law, it is there's standardized exams. You have to love it every
profession has standardized exams, and one of the tactics that they tell you is when you're doing for it, look for the least wrong answer. The only reason I said no with yours was the word punish, because I'm a trial attorney, and yes, trials are punishment in and of their own right. But they technically, the punishment's not the trial, it's what happens when you're convicted. The same thing back, you can't stand trial for the same thing 2 times. Of course you can. You could stand trial for something on the federal level and the state level. It's not attaching just to trial, it's attaching to if you are not convicted at trial, can they prosecute you again for the same offense? So let's say case goes to trial. Right? It's a criminal case, goes to trial. Somebody has been charged with murder. Right? About halfway through, the prosecution loses a witness. They know without that witness they're not going to win the case. They ask for a mistrial. They ask for the case to be dismissed, and the judge grants it. Can the prosecution then, if they find another witness, refile those charges and have the trial?
Yes.
Yes. Why?
Because it was a mistrial, a verdict wasn't reached.
No. Hey, does that matter? I mean, it's the prosecution's fault the witness isn't there, right? So, wouldn't that kind of put the person at risk for being tried for the same offense twice when they had no control over the matter being dismissed?
This sucks.
Let's make it better. What if the judge is the one who says, you know what, I am sua sponte. Does anybody know what sua sponte means? Sua sponte is a fancy Latin word that they teach you in law school to make you feel like you got some value for your $100,000. It basically just means on its own. If the court sua sponte, on its own, without the motion of any counsel, says, I'm going to declare a mistrial in this matter, can the prosecution then refile?
Not unless they have permission of the court.
Well, how do they get permission of the court?
The judge says they can.
Well, what if, just to say, what if the reason for the mistrial was material to it? And material meaning it is a leading factor, it's a leading cause.
Appeal?
Okay, I love the word appeal because we're getting there. We're getting there real soon.
From my understanding, they probably could motion the court, but it might not be granted. So
There actually is a huge area of law about mistrials and double jeopardy on this. And the leading thing is if the prosecution or the court were to move for a mistrial and it were to be granted, double jeopardy generally bars retrial if the reason for the mistrial being granted is material to the charge. If it's something that could not be cured by a new trial, it would be unfair to expect them to defend against. So in every situation, what happens, and you actually have the best one, a motion to the court, the question becomes, is this material, and who decides that? The court decides that. And then, say they're convicted, and they appeal their conviction. Then the first thing that's going to happen is the appellate court's going to look at, was there a material cause that should have prevented a retrial? Now here's the question, when does your double jeopardy attach? Let's say you don't make it to trial before the prosecution moves to withdraw or dismiss the case. So when does your right to not be tried again attach? Let's say you're arrested, okay? The police arrest you, you are being held in jail. The prosecution draws up charges to the grand jury. What's a grand jury? Yes?
There are a group of people who will decide whether or not a case can go to trial.
And how do they decide that?
I don't know.
Wonderful. Actually, I'll be honest, it doesn't matter because nobody knows how the grand juries work. Yes?
I believe the DA presents to a selection of jurors and they pick based off majority. If the majority agrees, they don't all have to agree, but the majority agrees.
That's absolutely right. But what are they agreeing on? Yes?
That there is enough evidence to warrant actually having a trial?
Okay, I want to point something out. How many people in here are not from the United States of America? Okay, the rest of you, I want to point out, one of the people who's not from the United States of America just explained a constitutional right to you.
Stole all the good ones from the British originally anyway.
It's okay, we won't have any left over after next
But
year
your
anyway.
judges have to finish.
Wow. They do.
Look, I'm not going to get on and say, you stole all the good ones from the British anyways. Yes, we did. We did. As I drink my coffee. But then immediately right after that, but your judges wear wigs. I'm not going to fault them. I want to wear a wig. I really do. I think it'd be really intimidating to have me in a robe and a wig yelling at you. It might not be Saturday morning at my house. That's the second part of that.
You gotta bang the gavel like a guy trying to hit a fly.
A grand jury is looking at whether or not there's a prima facie case on that to sustain the indictment, okay? Because that's what you're putting in front of a grand jury. You're asking a grand jury to indict somebody, and all an indictment is we have decided there is a prima facie case. What does prima facie mean? Yes?
Prima facie means like outside of any other evidence, so just like by itself without regard to...
In and on its own, at the first look on its face.
Philosophers know Latin.
Yeah. Yeah. Also, what it really means is, congratulations, we can up your tuition by another $10,000. They charge by the Latin phrase. So here's the way a grand jury works. A district attorney, or a prosecuting attorney, an attorney general, a U.S. attorney, whoever's doing it, will convene the grand jury. The grand jury will hear as many indictments as are presented during their term. A grand jury term, how long is a jury's term for? Did you say life? My God! Who here has done jury duty? How many of you want to be on a jury for life? Get that big $20 a day paycheck, parking not included.
Do I get vacations?
It's a special code.
Oh my God! I know. How long's a grand jury term? Life. No, the United States has the 8th Amendment. That's cruel and unusual punishment. A regular jury's term is obviously for the duration of what? A trial. Whatever case they're hearing. A grand jury's term is for the duration of however long a grand jury is supposed to sit. All right. A grand jury will sit for a period of time, not for a period of a case, and during that period of time, the grand jury will regularly convene to hear the arguments on it and decide whether it is. So a grand jury could do 3 indictments. A grand jury could do 30 indictments during their term. It just depends on how long their term is. Yes?
So a grand jury is just normal citizens
Yep.
called, just like we might be called for jury duty at a courthouse.
Correct.
Court case.
As a matter of fact, people who do get called for jury duty will sometimes be told, you're saying for a grand jury. Now, here's the difference. A lot of times a grand jury will be called by the state, not the county. Depending on where you are. I should always preface that. Depending on where you are, because every state's a little different. Yes, the ringer.
I might have missed this one, but what percentage of the time do grand juries not return an indictment?
Okay, who knows what lawyers say about grand juries? Yes?
Indict a ham sandwich.
Indict a ham sandwich. We can put a ham sandwich at the defense table and get it indicted by a grand jury. That is literally, it is such a low standard. It is just a horribly low standard. Why? Because it's just the prima facie case. And why else? Because, the prosecutor's got to sit up there and he's got to tell the grand jury, this is all the evidence we have that supports the probable cause and why we should go to trial. All right? Why is it so easy, though?
I'm assuming there's no defense.
No defense. They have a right to say nothing. Like their attorney in some areas may be able to be present and cross-examine, but a lot of times the defense has absolutely no right to present evidence, examination, or cross-examination during a grand jury. It is just the grand jury listening to the defense put their evidence up and then saying, okay, based on that, we think this should go to trial. Yes?
Would the defense even be there, or would they just, or would the prosecutor be there by himself?
Depends. And I say depends for a reason. Number one, it is based jurisdiction on jurisdiction. Every jurisdiction is a little different. Number two, grand juries tend to operate in secrecy. They tend to, there are plenty of times where somebody who's under a grand jury investigation is not aware of it until they are indicted. Second, there's not just one type of grand jury. Okay, there is the indicting grand jury. That's the grand jury where the case comes to them fully formed. Okay, and then there's another type of grand jury. What is that? Oh, come on, take a guess. Let me yell wrong at you.
Warrants?
Okay. Presenting charges.
Or determining charges?
Determining charges. What would they have to do to determine what the charges are?
Is it like more investigative?
There you go. And that's what we call it, an investigating grand jury. They look into the case and determine what charges are warranted, if any, and then they make a suggestion of charges to the prosecuting attorney. Those are somewhat rare. They are called, though. We are sitting in the wonderful Commonwealth of Pennsylvania. This is the Commonwealth I am licensed in and that I am an attorney for. Let me preface this. Nothing I am saying right now is the opinion of the Commonwealth Attorney, the Office of General Counsel, or the Governor of the Commonwealth of Pennsylvania. I am speaking as a private citizen. Okay? I have to say that. Like when I tell them I'm doing these things, they're like, here's the disclaimer before you say anything about this state, make sure they know. All right. Not being legal advice, completely different disclaimer. This is the one specific to my job. Pennsylvania, we don't do indicting grand juries very often. We have what we call a preliminary hearing process, and that means every crime that we have, if they're going to charge you, it doesn't go in front of a group of citizens, it will go to a magistrate judge. We have district court judges, and one of the things that they are required to do is hold a preliminary hearing. The preliminary hearing functions very much like, oh, you're running behind, honey, everybody else got me. So one of the things that they do is they basically hold the function of the grand jury and they decide whether there's enough evidence to bind the matter over to court. Once it's bound over to court, that's when the court of common pleas will start trial. Court will hear the matter. Other states and other jurisdictions have a similar thing. However, Pennsylvania will call an investigating grand jury, where they will probe in, call witnesses, subpoena, and question folks to determine what, if any, charges should be suggested to the Attorney General on a certain matter. So we don't really do an indicting grand jury very often. We do a lot of investigating grand juries here. Yes?
So the Attorney General or whoever is representing the state, they themselves don't just decide what the charge is?
Oh, no, they can. They absolutely can.
Okay, they can, but they...
What will happen a lot of times, and the reason that you would call an investigating grand jury is the Attorney General will have investigators, the police will have investigators, but sometimes you want the grand jury's powers on it. A very recent one, an investigating grand jury was called to look into abuses by the Catholic Church in the Lehigh Valley area of Pennsylvania. It was a series of crimes that ran statewide, that went back decades, and that the Attorney General simply could not pursue that heavily. And it added more validity to have a panel of citizens investigating, questioning, hearing the evidence, and deciding on charges than just the Attorney General doing it.
When they call it this any grand jury, the citizens themselves are probably legally ignorant of.
Trust me, buddy, most of the lawyers are legally ignorant.
Wow. I mean, is there like any lawyers or judges
No.
helping them?
Well, yes and no. Judges will provide some legal guidance. As a matter of fact, when you're even in a regular trial, when a judge is there, what is the judge's role? First, we're getting really far afield of what I was planning on talking about, but I'm enjoying it, so we're rolling with it, okay? First, let me ask you, not a grand jury. What is, we have the grand jury and we have the what jury?
Trial jury?
Yes, it is the trial jury, but it's got a nicer name. It's got another $10,000 name, and I want to know
Jury
if
of your
anybody knows it.
peers?
The bench.
I have no peers. The bench is the judge. Yes, in the back. The petite jury, the tiny jury, the micro jury.
You guys love your Latin, don't you?
Yes, we do. It lets us add money. The petite jury is what we call the trial jury. That's what it is. So the grand jury, typically 24 or so people sit on a grand jury. Then there is the petite jury, and that is the jury of your peers. That is guaranteed to you by, and what amendment to it? You know what? I forget it. I don't even think about it anymore. It is the Sixth Amendment, actually. The Sixth Amendment actually gives you the right to a trial by a jury of your peers. Now, let me ask a question. When do you, see, we're bringing it back around. We're bringing it back around to where it was. When do you have that right?
You've been charged with a crime.
With a state charge.
Any crime?
Oh, wait. Oh, but, is it? When you are charged with a felony? Did you say with this? Federal trial?
Say what? A state, did somebody say a state crime? Yes, you have no right to a jury in the federal system. In fact, we just sent one guy named Tom. He looks at you and goes, yeah, they're guilty, and walks off. Yes, in the back.
When there's an amount of damages,
An amount of damages.
like how Google got out of a jury trial by just paying the alleged damages.
I mean, like in a civil case, that makes sense, but what if the charge is murder? Is it like, oh, I'm sorry, there's no damages in here, just the death penalty.
Well,
You don't get a jury.
There's old English law where there is an amount of damages when you kill someone.
You're sitting right next to an old English person, so, yes.
It's only in the criminal court that you get trial.
Is that true, though? Because as we just heard over there, there's been cases where Google said, oh, there's not enough damages for a jury trial.
Wouldn't that just have been a settlement? Wasn't that just a settlement thing?
No, if they just pay it to the state anyway.
Has anybody here ever actually served on a jury, not just been called for jury duty? All right, in the back, what was the case, if you could talk about what was the case that you were on? Which, by the way, you can generally talk about it after the trial. There are some exceptions, though, and if one of those exceptions applies, you know it because the judge told you it applied after the trial.
Probably.
Okay. Domestic abuse case? That's criminal, right? Okay, who else? Orange. I see you, Bryant, and I'm coming to you, but...
Another one where a worker got hurt on a job, and
Oh.
they decided they were owed money for their basically going through physical therapy and stuff.
But as we just heard, you only get the right for a trial in a criminal case. So why were you sitting there? Or were you just an audience member applauding?
I was actually on the jury, and they were questioning everybody.
The idea, and I'm not jumping on you, this is kind of a Socratic thing, is, oh, okay, well, let's assume you're right. What's the response? Well, I said on one when we were giving people money, yes, you have a right to a jury trial in a civil case. However, when that right applies, depends on some goals. You heard back there, oh, well, it wasn't enough money. I can tell you right now, in my jurisdictions, we generally say if it's less than $50,000, you're not going to have the right to a trial by jury right off the bat. You're going to have to ask for it. You're going to have to go through standard mediation. Likewise, in a civil trial, unlike a criminal trial, you have to do one thing.
You have to request it.
Yeah, I gotta ask for it. You have to, at some point before the close of pleadings, you must ask for a jury. If you don't ask for a jury, it is presumed that you are consenting to the bench.
One question I had wondered about civil versus criminal law. I mean, as far as I understand, if you broke a law, that's a crime. So what is the basis for and if it's not something isn't illegal, there's no law saying you can't do it, then you're free to do it in this country. So what's a civil court?
I love that. The difference is money versus crime. Who is the party? Okay, a civil matter is a wrong against another person or an entity. Breaking a contract, not paying your rent, causing injury to somebody in a car accident. It's not necessarily a crime.
Well, I mean,
You may not have done anything illegal when you rear-ended the car in front of you. It does not mean that you didn't damage their car and hurt them.
but is there like a law that makes that a crime?
You're about to learn the wonderful world of the common law. What are the two general types of law that we have in the common law system? Yes, in the back.
Civil and federal, or
Okay, I just want to be really, really clear. Federal law is not a different type of law. It's just a higher type of law. I want to say to somebody like, but it's not a federal law. Okay, please stop saying that. Yes.
Civil and criminal.
Okay, maybe I should be more specific. What are the two types of the basis of law in the United States?
Statute law and common law.
Pardon?
Statute law and common law.
Statutory law and common law. What's the difference?
So statute is codified in our case by...
Actually, I like this answer right here because it is the simplest and the most correct. One's written down. That's what a statutory law is. What you think of when you look at the federal codes, when you look at your state laws, and if you look at it, if I write 75 PACS subsection 1547, that is statutory law. If I say, in the case of Pennoyer v. Neff, we are talking about common law. Statutory law made by legislatures is the codification of law. Common law is developed over time and mostly through legal rulings. And where do we get the common law from?
1,000 years of trying to figure shit out.
We get it from each other? No.
Other cases.
Yes.
We just kind of make it up as we go along.
Oh my God, yes. Absolutely, 100%. We get the common law from precedential court decisions. And that is a court that is going to hear things mostly on appeal. Let me ask, if the Allegheny Court of Common Pleas decides one way on a question and the Philadelphia County Court of Common Pleas, that's not what it's called, but it is what it's called, decides the other way on the exact same question, have we created a precedent?
In those regions.
Have we? Even in those regions?
Potentially.
Well, there are right now 13 judges on the Philadelphia County Court of Common Pleas. So if Judge Tom decides that way on that question, Judge Bob must follow it?
Not necessarily.
So we haven't even made it in that region. Even in Philadelphia County, Judge Tom's decision isn't precedential if Judge Bob doesn't have to follow it, right? It's persuasive, but it's not precedential. So it's not precedential in the same county. It's not precedential anywhere else. And what if Judge Tom decides in the next case, presented with the same question, he gets the same question in another case, does he have to say, I held that way in this case, therefore I must hold that way in this case? Absolutely not. He's not even bound by his own decision. Trial court decisions are never precedential. They are only persuasive at best. We get precedent from our appellate courts. Our appellate courts will hear a matter, and that's how the precedent is going to be determined. And then how they rule is going to be binding on every lower court, every court below them, within their authority. Unless it's not a published opinion. What's a published opinion? Yes?
An opinion that's actually gotten notoriety and a little bit of validity.
Yes and no. How would it get the notoriety and validity?
Well,
yes.
It was written down.
It was written down. Every opinion's written down. The judges don't just scream them at you. I mean, like, no, I'd take that back. I've had several judges scream their opinions at me. But they don't only scream them at us. Yes, and that.
It was added to the court record as an official part of the trial.
Okay, but how do we notate that?
Do you have some sort of law reports?
Say what?
Do you have some sort of law reports there?
Law reports! Okay, you know how I opened and I said there's no big book of law? I wasn't lying. There's about 300 of them. There is something called a legal reporter, and a legal reporter is the published opinions of the courts or in a region. Right now, Westlaw, which is Thomson Reuters, makes a small killing because they publish most of the legal reporters. Who here has listened to the Legal Funhouse? All right. You know how I'll read a case and I'll say, Thompson versus Crunch, and then I list off a bunch of numbers, and it sounds like I'm having a small aneurysm. What that is that's what we call the site. The site is telling you volume, which book in the volume, which series, what page. So if I say 392A2D 1156, this is the 392nd volume of the Atlantic Reporter, 2nd edition, page 1156, where that case is found. Okay? That is what published means. Published means when the court issued it, they said to be published or may be published, and now it's been gathered in this reporter, and now it's citable as precedent. The Atlantic Reporter gathers everything from the Mid-Atlantic region of the United States, every case from the state courts. All right? If it's a federal court, now we're in the federal reporters. If it's the U.S. Supreme Court, we are in the U.S. reporters. So once the court indicates, when we issue this opinion, we intend for it to be published, and some courts will just say non-published, to be published. In Pennsylvania, what our courts say is precedential, non-precedential. If it is to be published, it goes in the reporter. If it's in the reporter, it can't be cited. If it can't be cited, it is binding precedent upon every court that is inferior to the court that issued that opinion. Yes, Levesque?
Why don't they just publish it themselves?
I mean, they do and they don't. Right now, if you go on to the Pennsylvania Commonwealth Court's website, okay, there is a section on that website that reads court opinions. And you can go in there and you can see every opinion issued by the court, normally the same day that it's issued. Right? And at the top of it, it will say to be published, not to be published, or precedential, non-precedential. It's very time-consuming, number one, because you're going to have to cite to their direct one. It's not a common thing, cut citation. Let me ask what's easier. 392A2D 1156, PA Commonwealth 1993, or 111 PA Commonwealth 1456 through 1457 at slip opinion 4. And the courts can, you can go on to certain services and you can get the Commonwealth Reporter, which is just opinions of the Pennsylvania Commonwealth Court. That's all it is. Or you can, for the same price or less, get the Atlantic Reporter.
Apparently they tweet them out too.
Say what?
Apparently they tweet them out too.
Oh yeah, yeah. And now of course that's kind of archaic because
it's called X now.
Yeah, nobody has the big paper law library anymore. Those actually were still in style when I started practicing. When do you think they started phasing out the big paper publications as standard law offices? Yes.
I'm going to scarily say 2010, or around that time.
Go up.
2015.
Say what?
2015.
COVID?
Yeah.
2020. They still are.
2018 is generally. 2018, 2019 is when they start doing it. That's when law offices stop ordering them. And somebody yelled out, they still are? Yeah, they absolutely still are. That's just when most law libraries and most large firms stop saying, okay, we're going to stop ordering those every year. And why did they say that?
Save some money.
It saves them money. And do you know why it saves them money? All of the electronic legal research systems have stopped going from a per search billing area. Westlaw and LexisNexis are the two largest legal research systems, and the way that they billed for decades was per search.
So is there no way a citizen can actually look up the law?
Sure there is. Go to a law library. Every law library has a Westlaw and a LexisNexis terminal sitting at it that's open for use.
Most universities do too.
But then again, these different law library, there's a different law library for the local law, another one for county law.
There's one that, there are several, like you were sitting in Pennsylvania, okay, so it's got to be Pennsylvania specific here. Every county in Pennsylvania, by law, must have a law library that is open to the public.
Yeah, there's one of the, I think, courthouse.
Yep, that law library can be as simple as a Westlaw terminal and a Lexus terminal, but they must have one. Every law school has a law library. Most of them you can get access to. You have to go through some hoops to get access to them, but you can get access to them by going in and asking for a day pass or day access to the law library.
But like, there's no website I go to.
Oh, sure there are.
Research the law in general.
Sure there are. It's called Westlaw and LexisNexis and Fastcase, and you're absolutely free to go to them and pay for a subscription like every lawyer in the United States.
For a regular citizen, a lot of that stuff, you can find it on Google if you know what you're looking for.
Well, that's the problem.
Please stop sending people to Google for legal advice. Get the fuck out. Get out.
You know the precedent you're looking for. You
Google
can't find
uses
them.
AI, and I heard that story about that lawyer who tried to build a case using AI.
So anyways, back to what I was saying about how we decide that what's precedential and what's not. If it's published, it's precedential. If it's not published, if it's not marked for publication, it is a non-precedential opinion of a superior court, and it is now just persuasive. All right. There is an exception to whether the court gets to determine whether or not their opinion is precedential or not. What is that exception? Yes.
Is there a part of the Constitution it does say courts have to obey, like they have to recognize the decisions of other courts?
Absolutely not.
Why is it?
And Pennsylvania doesn't care what Texas thinks. The First Circuit doesn't care what the Third Circuit thinks.
Well, I thought there's something in the Constitution to that effect.
What you were talking about is called the Supremacy Clause. Okay. The Supremacy Clause is a clause that gives you the order of law. It is the supreme law of the country is the United States Constitution. Right below that are federal statutes passed by legislation. Right below that are federal regulations. Then the laws of the various courts are the laws of the various states. It's an order of laws question with that. Okay. Yes?
I have a question about like statute. You were mentioning statutory laws. What about the statute of limitations? Why?
That's not it. You're gonna love this. The statute of limitations, well written down, is simply a way to codify a common law principle called the doctrine of latches.
What?
Has anybody heard the words doctrine of latches?
I don't know what it means, but I've heard of it.
You don't know what it means, but you've heard of it?
Yeah.
Wonderful. You're like 90% of the attorneys I've met. Doctrine of latches. Does anybody know what it means? Okay. What's the statute of limitations?
It means someone cannot be charged for a certain crime after a certain period of time that's allowed.
All right, here's the fun thing. The statute of limitations, is it more important criminally or civilly?
It's more important in both ways.
Civilly.
Probably civil.
Civilly. Do you know why? There's a lot of exceptions to the statute of limitations for criminal matters. Right. Let's say you commit a crime in Pennsylvania. It has a 10-year statute of limitations. Typically, what is the statute of limitations for most crimes? Now, does every crime have a statute of limitations?
Nope.
What crimes don't?
Murder, rape.
Why?
Because you'll always have the body or a missing person as evidence. While another crime.
I could have evidence.
Because they said so.
Yeah, I could have evidence of a robbery for 50 years. It doesn't mean the statute of limitations is 50 years.
No, well,
The infamy of the crime.
Does infamy really matter, though? I mean, me crosswalking could, depending on where you are, be more important than me shooting Joe. Yes?
Because the damage is permanent, then you can't undo it.
Do we really care about the victim in the United States of America? Isn't it more of a blood sport? Yes?
Me or her?
Either one.
Is it because frequently the body and thus evidence is found long after the crime has been
As God is my witness, all right. I know what you're getting at, which is the corpus.
Yeah.
Is that how it's pronounced?
Here's the problem. Everybody has heard about the body of the crime, right? And habeas corpus, present the body, right? Okay, in law, corpus does not mean the actual body. Okay, it means the strength of the case, the things that are making up the case. So the body of the crime does not mean the literal body. It means everything that makes up the case. Habeas corpus, present the body, is another $10,000 in tuition, first of all. And second, is the legal term we use when somebody has been detained to demand that the state present the reason for detention to a court, which will then decide whether or not it is sufficient to hold somebody.
So basically, it's like, instead of present the body, it's saying present the body of the case. Like
Exactly. The body of, exactly. Every answer so far has gone around the harm that the crime causes and how we determine a criminal statute of limitations. And is that really what we're concerned about? Remember, the statute of limitations is a limitation on how long you can bring charges, how long somebody can be prosecuted for something, or how long you have to sue somebody. What is the main concern when we are time limiting things? And I'll even make it a little easier. I said it's the codification of the doctrine of laches. The doctrine of laches is a common law principle. The common law principle is you have waited so long to bring this, it is unjust, it is inequitable to force this person to now defend against it. All right? Yes, in the back.
Moving on to the next case, or next cases that we may have.
No, not really.
So it's a cruel and unusual issue.
No, not really. Yes, but no, not really.
Is it preservation of evidence and the continuation of
That is a consideration that goes into the common law principle of the doctrine of laches.
The difficulty to acquire evidence for prosecution?
Once again, that is a consideration that goes into the doctrine of laches, but not the statute of limitations. Yes.
Difficulties to defend against?
Of defending against, once again, a consideration that goes into the doctrine of laches, but not the statute of limitations. Remember, the question here is criminally, how do we measure a statute of limitations? How do we determine what that is? And why are some crimes going to have no statute of limitations while other ones do?
If somebody steals some money from you, you can technically get it back, but you can't bring somebody back to life, so it's permanent.
I like that answer, but it goes back to the same question of the harm. Do you all just want me to tell you at this point? What is a viable sentence for murder? Life. Life. What is a viable sentence for rape? Life. Now, people don't always get sentenced to those, but the sentence can be 25 to life, right? What is a viable sentence for mugging somebody? 5 years, maybe. All right. So, what's the statute of limitations for mugging somebody?
5 years.
Why?
Because you spent that time on the run, you served your time.
Say what?
Because that's the most that they're going to
That's the most time you could get in jail. That is how most times a criminal statute of limitations is measured. What is the maximum period of time that somebody can be in prison for this crime? Add on to that. You look very confused, and I know why you look very confused, because you're like, yeah, but I've heard about cases where somebody stole a car and then 30 years later went back to the state and went to jail for it. And you're absolutely right, you have, because you know why? We have something called tolling the statute of limitations, which is hitting the pause button on it. And you know one of the situations that starts running in?
Out of state.
Out of state, when you have left the state.
Like maybe Florida.
And when does the statute of limitations begin running?
When you come back.
When you come back again. When does it start running originally? When you're under the threat, when you can be arrested for the crime. There's all those things. So yes, it's a 5-year statute of limitations, but that 5 years requires you to spend 5 years in the state not having been charged with the crime. That's the other part. Okay? They have to have not caught you. You can't just be on the run. All right? You have to be within the prosecuting jurisdiction and not having been identified for the 5-year period. So that's why we also then don't have a statute of limitations on crimes that carry a life penalty.
Well, what I was actually thinking was that I was recall like with credit, you sometimes like someone business Fingerhut specifically, they just locked up my account for no good reason, demanded I send my identity information to them to unlock it. I refused. I told them if they didn't unlock it, I would simply wouldn't pay.
All right, I want to be very clear before you continue. You are in a room full of people. There's no such thing as privilege in this room. You're not the first one I've had to say this to, but like I had somebody once like, let me tell you about this thing the police want to talk before. And I'm like, please fucking don't. There are 40 people in here.
Don't talk to the police.
My point is that, like, with I've read that on my credit report, I found with the credit report, certain things, most things, supposed debts on the credit report will disappear after will be removed after 2 years because there's a 2-year statute of limitations.
Statute of limitations varies based on where you are when it comes to the civil matters, which are what you're talking about. The statute of limitations, what you had mentioned earlier, what got me on that whole tirade, a huge chunk of it when it comes to civil is about preservation of evidence, is about when it is equitable versus inequitable, and that begins running from the moment of harm. Okay? So in your situation, I've got this thing, I haven't paid that bill. In Pennsylvania, the statute of limitations for a contract case, with the exceptions of certain types of contracts I'm not getting into because that's an additional 1 hour on it, is 4 years. It is 4 years from the date of harm. What is the date of harm? How do we measure it?
The date the act was committed,
What act?
whatever the crime was.
This wasn't a crime. This is you just didn't pay your credit card bill.
The due date.
The day it was due?
The date they filed.
The date it went to collections?
Date it went to collections. Any other answers?
Probably the day you made the charge.
No. Think about it like this. Let's go through reasonably. If it's the day they send it to collections, well, they could hold it and not send it to collections for 7 years. The statute of limitations is 4 years. So that would give them, what, an 11-year period in which to bring a lawsuit? That's ridiculous. Yes?
I would say when the credit card, the bank that issued the credit card attempts to extract payment from you.
It is the later of the date of last payment or the date upon which payment was due. Because those would be the days that you breached the agreement. Okay, and why do I say the date of last payment? All right, you don't pay your credit card 5 years ago. Capital One's clearing its books, it gives you a phone call. It says, hey, we realized 5 years ago you didn't pay us and you owe us $10,000. Would you like to get on a payment plan for it? What do you do? If you're in Pennsylvania, what do you do? Well, let's assume you're not getting along.
Go back and fish out the old records.
Fish out the old records.
Tell them fuck off and end the call.
Whoa!
Any thoughts on that?
If it's Capital One, that is an acceptable.
Yes.
Go to the side, call the field station and cry for a bit.
Say what?
Cry for a bit.
Cry for a bit. Yeah.
Isn't part of it having to admit that you owe the money?
Actually, I want to go back to your answer because what does everybody think of that answer?
I respect it.
Give them the middle. We always give them the middle.
Okay. Number one, not legal advice. Talk to lawyers in your state. Number two, that's probably the most right answer.
Right.
Yeah.
Right.
Once you acknowledge or pay the debt,
Yes.
it comes back to life.
Yes.
Think about the facts we just gave. You owed Capital One $10,000. You made your last payment 5 years ago. We are in Pennsylvania, and the statute of limitations on most contracts is 4 years. If it is the later of the date of your last payment or the date upon which the payment was due, you've never made a payment after the last date the payment was due. So 4 years from the date that payment was due, it is a stale claim. It is barred by the statute of limitations. They call you. If you say, oh yes, I owe that money, I'll make a payment, you have now acknowledged the debt and they get an additional 4 years to sue you. If you make a payment, you have now acknowledged the debt and they get an additional 4 years to sue you. If you, pardon my language, say, fuck off and hang up the phone to go watch TV, they can sue you, but when you move to dismiss for the statute of limitations, you are most likely going to win that case.
Right.
You're welcome.
Yes.
Yeah, no, I just.
Both of you.
You said you were going to talk about the Fourth Amendment.
Yeah, no, we got way off track. Like I asked about double jeopardy, and now we're on the statute of limitations for Capital One.
time you call the bank, anytime you call up anything like that, you're going to get this call may be recorded for training purposes.
Absolutely. It's number one, if they say that, it's not, it may be recorded, it is being recorded, and it is not for training purposes, it is so they have a record.
Yeah, that's what I was going to say. I'm assuming that's
The maybe was for training purposes. It's still being recorded.
Like, they'll use it for training purposes, but that's not why they're recording it. Yes?
What does training purposes mean?
I mean, like, if you call them back and you're like, yeah, no, I didn't say that, and they pull it and they listen to it and they hear the person lie to them, they're going to be trained in how to find the unemployment office pretty quickly. Yes?
If you have someone who works for a 911 center where everything is recorded, more than likely it means that they are going to listen back to the line.
Wow, we have gone really far afield. Like, by the way, okay, because Brian here in the front row is absolutely right. I did say I was going to talk about the Fourth Amendment. It is very, very important. Don't let cops search your shit. Yes. Next.
Hey!
Honestly, though, no, to be very clear on this, I do have an entire talk about the Fourth Amendment that I give, which I was looking forward to giving today, and then you all got me talking about like basic legal concepts on grand juries. So, congratulations! Once again, you got me off track. But here's the rule on the Fourth Amendment. The police cannot search your things without probable cause to do it. If they do try to do that, or they search without a warrant or probable cause on that, that evidence may be excluded. However, and here's the really important part that I want to drive home to absolutely everybody in this room. Do not consent to a police search. If they are asking you, and you say yes at any point, or say it's okay, you have now consented, they do not need a probable cause, and they do not need a warrant. You have agreed to that search. If you say no, and they go ahead and do the search, and they needed a warrant, your lawyer can now argue that that evidence should be suppressed. It should be excluded. Now, there are exceptions to that, and most of the talk I do about the Fourth Amendment is going into the four major exceptions of it, and when they do or do not apply. And it's all very academic, and it's nice, and it's fun, and don't you wish you hadn't gotten me off track. But here's the main rule. If you say no, and they say, I'm going to search anyways, do me a favor and do yourself a favor. Don't argue with them. Don't fight with them. Just say, I want to make it clear, I am not consenting to this search. And if they proceed after that point, okay, tell your lawyer. Don't fight the police while they are trying to do the search, because that's how you end up extraordinarily dead. Yes?
Even if they do not find any evidence, would you still tell your lawyer about it?
Yeah, oh, definitely. Definitely. There is, they don't get off scot-free. I mean, like they sort of do, because qualified immunity is a thing, unfortunately. But there's a whole area of law about constitutional violations by the government. They're called Section 1983 Acts. And they are brought specifically by attorneys when the government or the branch of the government violates somebody's constitutional rights. Yes?
So do you get restitutions for them violating your rights like that?
That is a 1983 Act. That's what they are. That's most of what you hear of that are called, when you hear civil rights lawsuit in this day and age, most of the time what is happening is a government official has ostensibly or allegedly violated somebody's civil rights, their constitutional rights, their rights free from search and seizure and things like that. And so as a result, that government entity is being sued. Okay. 1983 authorizes, last year if you were here for the Legal Fund House, we talked about sovereign immunity and how you can't sue the state unless the state consents to be sued. So I think it applies to the federal government. One of the situations in which the federal government has explicitly consented to be sued is for constitutional and civil rights violations by government officials. That is under the Section 1983 of the United States Code, and that is the civil action for damages against the government for constitutional and civil rights violations. So, don't argue with them, but don't consent. And even if they say, okay, you're free to go, call a lawyer. Call your lawyer, tell them what happened. Your lawyer will make a determination as to whether or not it was justified a lot of times. Yes?
What if they find something that they planted, and before anyone has, I know this has happened.
Much less than you think.
No, man. You know what? No, I'm the government now. That never happens. No, he's actually got it sort of right. That's a common statement. They planted that on me. There is a little bit of confirmation bias on that specific thing, because the ones where it's very, very obvious that it happens are the ones you hear about. The ones where it is questionable or it obviously did not happen, you do not hear about, because it's not so obvious. It is questionable. Or you can look at the video, and I've seen some of these videos where it's been, they planted that on me, and I'm watching the body cam, and I'm like, they were 8 feet away from where it was found, like 2 seconds before it was found. And they were nowhere near anything. And so unless you're about to argue that this cop is walking around with like a gallon Ziploc bag of crystal meth hidden in his pocket, no, he planted nothing on you. That was just in the trunk of your car. Those are the ones that you don't see about, but the ones that you hear about where it does happen, and you see the video footage, and it is happening, that does lead to some form of a confirmation bias. Now, I have a good friend. If you're online, you may know him, T. Greg Duchette. And T-Dot has a long-running thread that he calls cops behaving badly. And all it is body cam footage of officers doing things they swore up and down they did not do. And him going, here it is. And pretty big threat at this point in time. Like, it's been going consistently for about 4 years now. Which is to say, we got a lot of bad people in certain professions that probably shouldn't be in those professions, but it becomes, even if it's less than what you think. You always hear there's not that many. Even then, this is a profession that is charged with the upholding of the law, and one's too many in that circumstance. And I don't cut I'm a government attorney. I don't cut slack with the government attorneys when I hear about a district attorney or an AG who is massaging their case a bit. The very first thought that comes into my mind is they need to lose their law license. And just working for the government does not give you the excuse. Get them clean or don't get them at all. One of the two. That said, we're past the time now. So,
is there anything you unofficially recommend to us given the current climate of the justice system?
Emigrate? I said this the other night. If you were here for the Legal Funhouse the other night when we were talking, and it really was. It was an hour of me complaining about Marbury versus Madison. But here's the fact of the matter. I would rather have judicial review than not have judicial review, which is the Supreme Court's ability to overturn things and find those unconstitutional, because if you put it on the balance of scales over honestly, in the scope of the world and limited history of our country, the power of judicial review has ended up in more good than bad. It has struck down more unconstitutional and discriminatory and oppressive laws than it has upheld them. But that power is only able to be used by the people who we have sitting on those benches. And when you have judges who are going to wield it as a weapon against oppressed peoples, it's a horrible thing. And when you have judges who are not going to wield it against oppressed peoples, it's a wonderful thing. The best example of how to go, when you say the best advice, who knows what the Dred Scott decision was? The Dred Scott decision, if you ask me, is one of the most shameful decisions in American justice. A slave ran away, had lived as free for years, sought in a free state prior to the Civil War recognition of his freedman status. And the United States Supreme Court came back and said, no, your property, so it does not matter how long you have lived free, you are to be placed in shackles and taken back into bondage in the slave state, and this state has no right to deny slave catchers from doing that. The Dred Scott decision, if you ask me, is one of the most shameful decisions, if not the most shameful decision in the history of the United States judiciary.
Shameful, that's just
It was overturned years later, but it has been overturned, it has been abrogated, and the Supreme Court now recognizes, even today's Supreme Court recognizes how shameful that decision is. My professional career has been dedicated to the study and the practice of law. And at some point within me, I have to believe that we will have a court that will once again look at some of the things that are going on and use that power to repudiate what is happening in this day and age and time. So the first thing I can always say is persevere and have a little bit of faith. Now that's horrible advice because it does not matter how much faith you have if you are being attacked. So take care of yourself. Be safe, find ways to backstop it. And to some extent, at this point in time, if you have not reached out, we have been spoiled a little bit over the last 30 years. It doesn't seem like it, but in Supreme Court jurisprudence, that has been progressively getting better. Maybe start reaching out to people who lived before we had some of these rulings and find out what they had to do to protect themselves. I, not too long ago, had a gay couple I know who went in and got very, very detailed estate planning documents that they technically shouldn't need. They're married. But we don't know what will happen if Obergefell is ever revisited by the Supreme Court of the United States. So they said, we want to go back and we want to get the same type of estate planning documents we had to get in 1993. Because we want to make sure that if something happens, these rights are going to be supported. And I was half joking when I said it earlier. I do mean it. And this one isn't legal advice so much as it is from my family's history. I was raised Southern Baptist. My maternal grandfather was Jewish. My paternal grandfather was Jewish, and so was my paternal grandmother. My spouse's family were Polish Jews. And those parts of our family came over from a certain area of the world in a certain time frame. And there is a phrase that we both grew up with. Keep a packed bag by the door. So if you have to leave, be ready to leave. Outside of that, man, that was a really upbeat note to end on. Folks, thank you so much. I'm sorry I didn't get the most of what I did. Normally, if you do see me at another con that's not this one, when it's not 10 a.m. and I'm not under-caffeinated and angry, we'll be actually doing the constitutional matters there. I am Boozy. Please enjoy the rest of your con.